Hello, everyone. Welcome to copycamp. My name is Jarosław Lipszyc, and I'm the moderator of today's session. Copycamp is being organized by Modern Poland Foundation, a small non-profit organization based in Warsaw, Poland. We are running the most popular digital library in Poland, which is called Wolne Lektury, free books. And this is why we got interested in copyright in the first place. And we are happy that you share this passion with us. Copycamp is a place to discuss copyright in an interesting, substantive, and engaging way. It's not a law conference. This is the conference on social impacts of the copyright. And for the past 9 years, we shared these experiences with artists, experts, scientists, and social activists. We show how copyright is important basically for everyone in the time of digital society, and we are happy that we can do this for such a long time. We would like to thank our partner, which is Google, who decided to support Copycamp in this unusual year, despite unusual format due to the pandemic. And so today we have 3 speeches. Each of the presentation will be no longer than 15 minutes. And after that, we will start questions and answers session. You could ask questions on YouTube chat or via Matrix on the copycamp.pl website. We will choose to ask our guests most of them, as many as possible. If there is anything we should improve before tomorrow, please let us know in the comments. This is the first time we organize such a conference, and we definitely need your feedback. The title of today's session is Content Filtering and Other Internet Disputes, and our speakers are Julia Reda, Justin Jute, and Julia Priora, and Edyta Bednarczyk. Julia Reda is copyright expert and project lead at German fundamental rights litigation organization GFF. Julia was a member of the European Parliament between 2014 and 2019, where she focused her work on European Union Copyright Directive and the regulation of internet platforms. The title of her presentation is Article 17, What is it really good for? Julia, please, the floor is yours.
Yes, thank you. It's a great pleasure to be here, and I have the difficult task of talking about Article 17 in only 15 minutes, so I will do my best. As most of you probably know, Article 17, or also called the upload filter provision, is probably the part of the new European Copyright Directive that has been the most controversial. And there were actually quite big protests against upload filters when the directive was adopted, especially in Germany. But what has received a little bit less attention so far, and what I want to talk about today, is the fact that even though the member states of the EU have not yet actually implemented Article 17, they still have time until June to present their national implementations. Article 17 is already before the European Court of Justice. This is because the Polish government, after the directive was adopted, started a complaint at the European Court of Justice saying that parts of Article 17 violate fundamental rights, in particular the freedom of expression and information. When this complaint was initially launched, a lot of commentators didn't take it very seriously because the complaint came just 2 days before the European elections. So some people thought it was more for the election campaign than really for the substance. But now there has actually been a hearing at the European Court of Justice on the 10th of November, which has shown that at least the court is definitely taking this case very seriously. And the results of this court case could have a very significant impact on the way that member states have to implement Article 17, if they have to implement it at all. So today I want to tell you on the one hand what happened at this hearing, what questions the court is looking at, and on the other hand also present some results of a study that my organization has done on the fundamental rights impact of Article 17. So at the core of the hearing, there were 4 different questions that the court asked. On the one hand, to the Polish government, who was arguing that Article 17 violates fundamental rights. And then on the other hand, to the European institutions, so European Parliament, Council, and Commission, and also to the governments of France and Spain, who also intervened in this court case, arguing that Article 17 does not violate fundamental rights. There is no ruling, no judgment yet. We think that the final judgment will probably come next summer, but this means that it will probably come after the implementation deadline of the directive. So the first question that the court asked is one that was also discussed very strongly when I was in the European Parliament, which is, does Article 17 make upload filters mandatory? The supporters of Article 17 for the most part said, well, actually, the words upload filter are not in the text, so it doesn't make upload filters mandatory. The platforms have a free choice to decide how they want to ensure their best efforts to prevent copyright infringement from happening. On the other hand, Poland was arguing that in practice, the platforms don't have another choice than to use upload filters because there are no alternatives that can actually achieve this objective. What I think was very interesting at the hearing is that the court, the Advocate General, were not just looking at the exact words of what the provision says, because it doesn't say upload filters anywhere, but they also looked at what it actually will have as an effect. So, for example, the Advocate General was asking the parties, well, if you are required by law to go from Luxembourg to Brussels within 2 hours, do you really have a choice whether you want to use a car or whether you want to go on foot? Which I think kind of describes the problem very well. So from a fundamental rights perspective, it's basically saying, does the legislator have the responsibility to pass a law that ensures that fundamental rights are protected even when a private company is following that law? The second question was what effect the upload filters actually have on freedom of expression, because we know from the discussion around Article 17 that the upload filters that exist, that some platforms are using voluntarily, make a lot of mistakes. So they often also delete legal content, for example, Creative Commons or public domain material, but also uses of copyright material under exceptions. This was mostly a question about what fundamental rights the different parties deem more important. So especially France and Spain argued that even though, yes, legal content will be deleted, that actually the fundamental rights of the right holders, the copyright holders, should always be valued higher than the fundamental rights of users. Now, I'm not sure whether the court is going to follow this argumentation, but that was basically the core of this question, whether the fact that legal content will be deleted, which pretty much all the parties seem to agree, whether this is actually an acceptable restriction on freedom of expression. The third was very interesting because here the court was basically asking how Article 17 should be interpreted, because Article 17 is actually contradictory. On the one hand, it says the platforms have to make best efforts to remove copyright infringement, but Article 17 also says that legal content must not be deleted. And the member states have interpreted this very differently. For example, in Germany, the national proposal for implementation includes specific rules, for example, saying that things that are shorter than 20 seconds should not be blocked. Whereas in France, there are no rules for ensuring that legal content does not get blocked. And so on this question, actually, there was a huge disagreement between the different supporters of Article 17, because the European institutions, especially the European Commission, argued that only manifestly illegal content must be deleted under Article 17, because otherwise the obligation to leave legal content online would be violated. This is, I think, very different from what a lot of rights holders have in mind. And also Spain and France argued the exact opposite. They said everything that gets found by the upload filter has to be blocked. And then if it's an exception, like a quotation or a parody, then the user can complain. So huge differences there. And the final question was about actually the data protection rulings that the court has made in the past. So in the Max Schrems ruling, the court said that actually the European legislator has a central responsibility to include safeguards for the protection of fundamental rights in the European law. And so the question was whether Article 17 actually does that, because like I mentioned before, it's a bit unclear. Even though Article 17 says legal content must not be deleted, it's totally unclear how this should actually be achieved in practice. So this indicates that there might be a missing central safeguard. On this, of course, there was also a lot of disagreement where the supporters of Article 17 say that the safeguards are sufficient, whereas Poland argued that they're not sufficient. So I think the most important outcome, perhaps, of this hearing is that there are completely incompatible interpretation of what Article 17 actually requires from platforms, even among the people who agree with Article 17. So the version that France and Spain have in mind, basically anything that gets caught in an upload filter gets deleted. And then the only protection for freedom of expression is that users can complain and then have it maybe put back online. This would be a huge problem for freedom of expression, of course, because communication on the internet, especially about political topics, is most relevant at that moment when the communication is done. Like if you post criticism of a current political event or live stream from a protest, it gets blocked, and then maybe a week later it gets put back, then the damage to your freedom of expression is already done. So this means that even if the European Court of Justice decides that Article 17 does not violate the Charter of Fundamental Rights, there could still be very important statements by the court about this question, whether only manifestly illegal content should be deleted or whether everything should be blocked and then users have to complain. So in order to also push forward the academic discussion around this court case and around the question whether upload filters in general can be considered compatible with the Charter of Fundamental Rights, my organization, Gesellschaft für Freiheitsrechte, has just published a study. I will share the link at the end, which is looking at exactly those questions in detail that the court has asked. So I'm just going very quickly through a few central results of our study. If you want to know the reasoning, unfortunately, you will have to read the study because it's impossible to put into 15 minutes. So first of all, we looked at the European Court of Human Rights case law, because the European Court of Justice will have to take this into account when considering whether there is a violation of freedom of expression. And there we have found that the European Court of Human Rights actually considers any law or court order where content is blocked before a court has decided that it is illegal as a form of prior restraint, which means that it's only allowed under very, very strict circumstances and there have to be strong safeguards. This is obviously the case with Article 17 because there is no court order. It's basically just a right holder sending an information to a platform, and based on that information, the platform has to block. The second result is that the use of upload filters does not just directly restrict freedom of expression, but also indirectly through so-called chilling effects. This means that if somebody becomes the victim of wrongful blocking, they will use the social media platform less in the future because they might be scared that they're being surveyed or that their content might be blocked. The third result is that the safeguards included in Article 17 are insufficient to protect freedom of expression. Because on the one hand, Article 17 says legal content must not be blocked, but it doesn't include any sanctions. It doesn't include any mechanism to make sure that this actually happens. On the other hand, the requirement to remove illegal content has very strong sanctions, because if a platform doesn't do this, it becomes directly liable for the copyright infringement. Finally, we also looked at the effects on platforms, because in the past, the European Court of Justice has considered upload filters not just from the perspective of fundamental rights of users, but also fundamental rights of platforms. And there we found that Article 17 violates the freedom to conduct a business of platforms, because the safe harbor provision, which means that platforms are not liable for copyright infringements of their users and are not required to generally monitor all the user uploads, this safe harbor is no longer applicable. And the impact is especially bad for smaller platforms, because our estimates show that they would have to spend a really large portion of their revenues on quite costly filtering systems. And so these are the central results of our study. Now, of course, you may know that a lot of member states have already started implementing Article 17. And since the European Court of Justice is not going to deliver its ruling in time, they kind of have to anticipate now what the court might do. In April, we will get the Advocate General's opinion on 22nd of April, which is a first indication of what the court might decide. The options are, it could say that some parts of Article 17 are void because they violate the charter. So this would be the parts that require the use of upload filters. The court could also say the entire Article 17 is invalid. It could say it's valid, or it could say it has to be interpreted in a particular way. The problem is when that ruling is delivered, probably next summer, even if the court says Article 17 violates the charter, it will already be too late. A lot of member states will already have passed national legislation. And as we know from the past, in this case, the legislation doesn't automatically become invalid at a national level. So we had this with the Data Retention Directive, which was declared invalid, but then you still had a lot of national data retention laws. And this is also where our work as GFF comes in, because we do strategic litigation. So we're looking very closely at the results of this court case. And should it the result be that the national implementations violate the charter, we would also be able to start strategic litigation in the member states. And we'd be very interested to talking to other NGOs in other countries about these plans. So this is what I wanted to share. On this slide, you have my contact information and also the website where you can download our new study. So thank you very much for your attention.
Thank you, Julia. Thank you to all of you listening to us. Please keep in mind that you can ask questions to Julia on copycamp.pl website or directly on YouTube chat. The speakers will answer your questions after we finish the presentations. Justin Ute is assistant professor in intellectual property at the Sutherland School of Law, University College Dublin. His research interests focuses on digital aspects of copyright law in the European Union, in particular transformative creativity and the role of fundamental rights. And Julia Priora is postdoctoral researcher at the Institute of Law, Politics and Development at St. Anna School of Advanced Studies in Pisa, and affiliated researcher in the Center for Media Data and Society in Budapest. Her research focuses on intellectual property law and European Union digital innovation policies. The title of their presentation is Teaching Exceptions for Exceptional Circumstances, Learning from the Pandemic for a Proper Implementation of Article 5, Digital Single Market Directive. Justin and Julia, the floor is yours.
Okay, wonderful. Thank you very much, Jaroslav. Thanks for having us. I will see if the screen sharing now works. Give me a second. And now you hopefully see my slides. Julia and I will be discussing a provision of the DSM Directive that hasn't gathered the most attention of all the provisions that are contained therein. However, given the recent events with the COVID-19 pandemic, it has become more relevant than I think most commentators thought in the very beginning. So Article 5 deals with what you can call a teaching exception 2.0, a teaching exception that has been enhanced, however, also has a number of significant pitfalls included or integrated in its formulation. And Julia and I, in the next 12 to 15 minutes, will walk you through the teaching exceptions. I will introduce you to the structure, and I will tell you what is new about the teaching exception that we find in Article 5 of the DSM Directive, as opposed to the teaching exception that we still find in Article 5, paragraph 3, letter A of the Information Society Directive. And Julia will then take a look forward based on the lessons that we have learned as academics teaching online over the last couple of months, why a proper implementation of the teaching exception is so important, and what dangers lie in an undiligent or uncareful implementation of said provision. So the old teaching exception in Article 5.3 of the Infosec Directive was relatively slim, or was relatively simple in its formulation. It merely said that under certain circumstances, material can be used for the purpose of illustration of teaching, but it certainly wasn't an exception that was limited either to the analog domain, nor was it expressly limited to the digital domain. It was limited to no domain whatsoever, and member states were free to implement it in whichever way they thought it was appropriate. There were a number of constraints integrated into the exception, namely that the source has to be indicated whenever a work protected by copyright is used for teaching purposes. So the author has to be named, has to be credited, and all the uses must be for non-commercial purposes, which of course reflects the basic understanding of teaching, that is a non-commercial, essentially a public good that is being provided for by the state. However, of course, it shared the problems that all the exceptions of Article 5, paragraph 2 and paragraph 3 of the Infosec Directives had in common, namely that it was an optional exception. That meant member states could choose to implement it or not. That meant that we found a teaching exception in some laws of the member states, but in others we wouldn't find it. And of course, due to the nature of copyright, the effect of the teaching exception was always very limited to the territory of the state under which a certain teaching exception was relied upon. And we've learned from the case law of the Court of Justice that a making available of protected content via the internet infringes all the applicable internet copyrights in which the content is accessible, meaning that if a teacher under a nationally implemented teaching exception were to make content available on the internet, that would infringe, if no such exception were available in other member states, copyrights in a number of other European member states, of course, creating a large amount of legal uncertainty. And in the same way that under Article 17, we have a chilling effect on speech, here there could have been a chilling effect on teaching, which is, of course, why most universities recommend their teachers to use as little copyright protected content as possible, and rather rely on content that either has been licensed or to which the teacher held the rights him or herself. So this created what we call a toxic mix of different national approaches, escalated by the principle of territoriality. And to be sure, to be safe, a teacher would only use the teaching exception in analog teaching. So de facto, a digital teaching exception was very, very difficult to implement, but also to exercise by an individual teacher. But however, the exception left room for a digital application, which we see in the Irish example, which I only got to know quite recently. But in 2019, the Republic of Ireland introduced an express addition to the existing teaching exception that then turned it into a digital exception, however limited to Irish works. That means works published in Ireland. That, of course, limits the scope of teaching material available online significantly. Now, how did the new exception that we find in Article 5 of the DSM Directive change the old exception? Because this revamping of the exception, of course, generated new opportunities for the legislator to correct the wrongs it had made in the past. So there are certain similarities to the effect that the constraint that we already had, so attribution, for example, are still contained in the new teaching exception. And of course, that does absolutely make sense. But of course, there's one very important point in Article 5, in that it introduces a country of origin, meaning that the act relevant under copyright law, that is the posting of content in the context of teaching activities, is by way of legal fiction deemed to occur in the country where that act is exercised. So it removes this legal uncertainty created by the principle of territoriality and enables teachers without many restrictions or fears of violating the law to put content online as long as they comply with their nationally applicable copyright exception, which also means one added benefit of the new exception is that there has to be a copyright exception for the purpose of teaching, because Article 5 now is mandatory in all the member states. They have to provide for a teaching exception that at least covers digital users, because this is the limitation of Article 5 of the DSM Directive. There is also the horizontal benefit of Article 7 that applies to all the newly introduced exceptions of the DSM Directive, that this provision cannot be overridden by contract. So publishers that make available, for example, ebooks to certain education institutions cannot, by way of license, argue that these types of content cannot be made available in an online environment specified in the directive. However, and this is quite unfortunate, at least that's what we argue, the European legislator itself included an override, and not necessarily by contract, but by law, in that it introduces the possibility for member states to derogate from the exception, to create an exception to the exception, to the effect that licensing agreements concluded or made available by publishers can override the direct applicability of the teaching exception. So when publishers make such licenses available, the teaching exception or the pure teaching exceptions would not apply. And of course, the exception is tailored for educational institutions. So the scope is limited to certain education institutions and cannot be taken advantage of by non-education institutions. So the personal scope, so to say, is also limited by the wording of the directive itself. And then also an element that hasn't been present in the old teaching exception is the fact that member states can foresee a compensation mechanism. A compensation mechanism which would then be very similar to that we already find in relation to the private copying exception, that there will be some sort of financial balancing between the education institutions that use content under the exceptions and publishers or other right holders, meaning that it's not an exception that can be taken advantage of for free, but under two potential implementation models, it would mean that education institutions would have to pay directly or indirectly for content made available under the exception. With this, I will now hand over to Julia, which means I will stop sharing and Julia will start her part of the presentation.
Thank you very much. Hope you can hear me well and also see my screen in just 1 second. If it's not the case, please let me know. Feel free to interrupt me. So thanks, Justin and everyone. I just ask you to bear with me for a few more minutes because what Justin has just illustrated to us is something new that is coming up next, hopefully by June 2021 in all member states. And of course, it's an occasion. It's an occasion to, as Justin was rightfully saying, to make something better and specifically to make our teaching exception better and more fitting ever more digital environment. But the question we posed ourselves, and now I am proposing to you, is whether this new digital teaching exception is a real solution, is a fully fledged solution to the problems we had and still have with the old, so to say, InfoSoc teaching exception, or rather we have something that apparently is a solution and is something good, but ultimately will turn out to be something similar to a teaching placebo. So we are using this medical metaphor to get a little bit more pragmatic and to the point. So the way ahead that Justin and I foresee, but also envision in light of the scholarship that has been developed so far, is actually a twofold way ahead. On the one hand, national parliaments, national legislators can actually opt for the bright way, the one of a pure exception or of a full exception. So understanding these as an occasion to really help carving out room for copyright protections to step back and to allow a sort of new environment, a digital environment for teachers and users to use materials, protected materials, without any concern, without the fear of encompassing copyright violation or encountering any sort of sanctions. This, of course, is a way that, as Justin already pointed out, could come together with a compensation scheme or without a compensation to be envisioned. On an alternative way that you see on the bottom of the slide is actually if a national legislator looks more for something, let's say, more balanced, in the sense that instead of looking for a pure exception, it goes for a license-based implementation. So basically giving more importance and having exactly the override that Justin was pointing at by giving priority to licenses that are available in the market, that publishers will make available to the public and to teachers and students in this case, to allow this to become actually the reality and give them priority over the exception itself. Now, we want to flag and draw your attention to two of the problems that we see particularly relevant and urgent to be addressed at this very time during the implementation process. And it's exactly revolving around the compensation and the license, let's say the priority to license, so the de facto overrideability of the exception itself. Why do we say so? Well, basically, ours, as we are both coming from the field, ours is a legal analysis, but this is also a legal analysis that is conscious and informed about the pragmatic and real life implications and effects that a teaching exception, and I'm putting a lot of emphasis on really the first word, the fact that education is definitely a pillar, and it's not just us saying, but it's the EU legislator and all national legislators saying one of the pillar of the free uses and the free culture that should be balanced vis-a-vis copyright protection. So our let's say our analysis and our structure of the reasoning actually signal four main warning signals already. And this is a very early stage because we are looking at an exception that has not been implemented yet, if not in Hungary. So we are still looking for new proposals and how the whole process will unfold. The first warning being, if we start seeing that national legislatures will use it as an opportunity to actually exclude some uses or some works from the scope of this exception, this may actually ultimately lead to a sort of hollowing out of the role of the exception. So making it very ineffective in terms of too many works and too many uses will ultimately not find application, will not see the real life and real effect of the teaching exception as it is meant. Another warning signal that we can see and envision, also looking at other copyright exceptions within the European scenario, is whether the extent of the use of the permissible use of a work will be actually the one being limited. So definitely the notion of short fragments or percentages as 15% percent of a book ring a bell, especially among those of you who are familiar with other copyright exceptions. Justin was mentioning private copying being probably one of the most famous ones. But definitely this is, again, very much jeopardizing the role and effectiveness of the teaching exception, even this new one. Then we have a point that is probably very obvious to mention. It may sound trite, but yet it's something that we need to take into consideration. The licensing-based scheme and the compensation-based schemes are mostly driven by publishers' capture effect. So we definitely have the publisher pushing for this sort of schemes and ultimate solution on behalf of right holders, but not always actually protecting their best interest of authors and individual right holders, but rather going towards big companies. Another warning signals that we actually spotted from the very literal analysis of the exception is the fact that borderline uses between teaching and scientific research will actually have a hard time finding a space in the application of Article 5, as we see that only the teaching part remains and the scientific research actually has already fallen away. Well, we do want to conclude our presentation leaving a sort of constructivist but also optimist note. So definitely the approach that we want to emphasize on is that it's better safe than sorry, especially when it comes to copyright exceptions. And I think also the previous presentation by Julia Reda really gave us a very nice insight also on how this is specifically the case when we look at the digital environment. Now, obviously, we are keeping, as probably most of you, an eye on the implementation process in all member states. As I was mentioning, Hungary is the member state who implemented first this Article 5 DSM Directive, but there are also explanatory documents that are giving us good insights on how probably the implementations will look like. There are some silver linings. So there's definitely reasons for hope in the sense that not all the implementation seems to go a very worrisome way. There seem to be no further limitations of scope so far. Definitely, there is also no push towards taking this Article 5 as an occasion to lift some of the limitations that were there with the implementation of the old teaching exception from the InfoSoc Directive, looking mostly at analog uses. We have also a new teaching exception which look at online teaching, which is mostly associated with this strong link to, well, let's just put in the legislation that the article we had from the 5.3a of the InfoSoc Directive applies also in the digital context. This is obviously controversial because we should go and see on a case-by-case analysis what that exception in the member states meant. And definitely there is no push towards overly burdensome compensation systems at play. Nevertheless, obviously the picture we are drawing to you, hopefully you could bear with us and see it, is quite ambivalent. There are definitely some pitfalls and there are definitely some points of strength. And we want just to convey the message that probably, again, it's trite and over simplistic, but Article 5 DSM Directive could be the best probably occasion we have right now to reflect and build a proper user perspective within EU copyright law. And definitely I'm looking forward also, we are looking forward for the discussion and your input, but that's something that the scholarship has tried to build now for more than a decade, and it seems to be a very difficult exercise to do. Why it's so difficult? We know many different interests that are at play, and I wanted just to mention an example, a project that is particularly dear to me and I'm working on with a tremendous consortium of partners. Recreating Europe is, for example, one of the many scenarios where this user perspective is trying to be analyzed and really pragmatically taking into consideration as its whole. So I think on this note, I thank also on behalf of Justin, and we look forward to your comments.
Thank you. Thank you, Julia. Thank you, Justin. Please keep in mind that you can ask questions to Justin and Julia on the copycamp.pl website or in the YouTube stream chat, and we already have many questions to you. But the questions will be answered after the last presentation of today. Edyta Bednarczyk is a student of law department at Jagiellonian University in Poland. And she was also studying in Beijing, China, and Heidelberg, Germany. And she was giving speeches on sampling and copyright protection in China. The title of her speech is German Golden Mean. Edyta, the floor is yours.
Thank you very much. Everything is okay with my micro?
Yes, it's fine.
So one more time, thank you very much for the opportunity to take a part in this conference. Not once I had an opportunity to read papers provided by people that were speaking before me, especially about Article 17. So it is an honor to be in here. In my presentation, I would like to describe draft of implementation, the Article 17, prepared by German Ministry of Justice. It is widely commented as the one that is the closest to the text of directive and also to the aims expressed in recitals. In October, the ministry has released another discussion draft and called for opinions. And I would like to present them as well. During big protests against the directive and fears about common censorship of the internet, people in Germany were promised that there will be no upload filters. The works upon the new act showed that actually it is very difficult to fulfill that promise. So the main stress in the draft has been put on the minimalizing over blocking. The only way to skip from the responsibility is acquiring the license or removing and blocking unauthorized content. The most significant is that the responsibility of user-generated content platforms has been stated in the act, which is separate from general copyright law, just with numerous references. This allows assuming new regulation as a separate regime and somehow explains easier the doubt about compatibility with InfoSoc directive. The service provider is responsible for the content that is typical for certain platform. So YouTube for videos, Instagram for pictures. That means that all measures taken in order to check the content can focus only on those certain types of content, and as a result, it limits somehow the need to filter. It is also important that the draft defined the blurry term best effort in acquiring the license, stating that the need to purchase such a license only if the license has been proposed to them, or they can pay to the collective community. Regarding the discussion of rights to the retransmission and cable TV in the previous time, the help of collective communities seems to be a useful solution. Another important proposition is providing a distinction between automatically non-verifiable and verifiable use allowed by law. The first concerns already existing limitations, like, for example, citation or parody. Second one introduced the new exception, stating that the communication to the public for a non-commercial purpose is allowed when in the new work is implemented up to 20 seconds of film, 20 seconds of audio or music, 1,000 characters of the text, and 250 kilobytes image, which was already today mentioned. First problem with that de minimis exception is that those amounts are, of course, totally inflexible, which sometimes can lead to absurd in some cases when 20 seconds can have different meaning for certain and value for the new work, and it can be quite unfair sometimes. And of course, it raises a question about the compatibility with the InfoSec Directive. In Article 5 is a list of limitations that member states can implement into national laws, and this catalog is regarded as the exhaustive. However, even if this tool is quite blunt, it somehow answers on the need to limit overblocking. Some scholars recommended removing this article until the European Commission will provide us with a more specified guide. Otherwise, it can lead to plenty of problems if after the implementation such limitations will be marked as the repugnant to the law. And probably being aware of the imperfections of the minimis exception, this way of justifying the use should be used as the last one after seeking for the possibility with license and the statutory exception, the classical one. This seems to be a proportional solution. And according to the opinion prepared by Max Planck Institute, there is no need at all for the minimis exception, while also in the draft, the license obligation involved only the representative repertoire, which was provided by the right holder, and according to the opinion, that this is enough to comply with the directive. Another tool is the remuneration obligation imposed on service providers. It obtains after use under the minimis exception, and what is new in compare with previous drafts for the pastiche. It is a good solution that to use the pastiche, to use that exception to user-generated content, while this exception has been already pointed as the most useful for the user-generated content. As says the Merriam-Webster English Dictionary, it is a literary, artistic, musical, or architectural work that imitates the style of previous work. Also, it has been said that it can also incorporate parts of already existing work and can be used in medley's production, so it sounds just like a definition of memes. Obligation of remuneration is a peculiar solution, while usually pastiche, as well as the caricature, parody, or citation are free also of charge. However, this may incent right holders to mark content, to allow to market as a pastiche, and to leave the content online just to get remuneration. The problem eventually may lay in the conflict of interest, because probably the content that needs to be marked as a pastiche will be checked by the service provider himself. So, if the platform assumes, for example, a video as a pastiche, he needs to pay remuneration. If not, and if the use won't fall under the minimus exception, there will be a need just to take down and block the video. There is a problem then for them to stay neutral. And finally, how actually enforce those measures without general filtering of each work uploaded by users. The remedy, or at least some help, supposed to be a system of pre-flagging. User, according to the previous draft, should have an opportunity to flag the content as authorized, or on a base of contract with the right holder, or on the base of the exception, also de minimis. Those work cannot be filtered, removed, or blocked from the platform. It sounds fair. However, two problems pop out, also the second one recently. The first is that if the content is obviously incorrectly flagged, it can be still blocked. As such is regarded the content, according to the draft, uploaded by the user that corresponds to at least 90% of the information provided by the right holder. This paragraph created the risk and temptation to introduce the general filter in order to pick wrong order up, and was quite strongly criticized. Unfortunately, instead of fixing this article, it became even worse. In the last draft, that pre-flagging attitude has been exchanged for a pre-checking attitude, according to the information from the document calling for opinions about the draft. That means that before the user will have an opportunity to flag the content, first it will be checked whether it contains a third-party elements which are already licensed. If so, the work can be uploaded. If not, then the user shall be provided with the information about doubts and possibility to mark the content as authorized in a different way. In the draft itself, I don't really see from where this pre-check attitude comes from, since the new part in the paragraph 8 of the draft says only about informing. The pre-check attitude is briefly mentioned in the call for opinions document. While reading other paragraph, I am not able to notice that. The new article says that the service provider is obliged to inform the user about the right holder's claim to block the content. How I understand that is the information obligation concerns only hypothetical possibility of blocking if there is no license, to make the user aware of that and then enable the user to flag the content. However, for that part, there is yet no English translation, so I guess that this may be the reason that I cannot see that change. And this is also a reason why I haven't put that into the presentation. Yeah. And anyway, let's assume that the attitude has been changed. Then I need to say that even if the first system had its shortcomings, for example, it couldn't work for the content that is already on the platform, or it doesn't work for live streams in which the user cannot prefigure what will be streamed. Also, terms like parody or pastiche, even if, according to the Court of Justice judgments, should be understood like it is understood in everyday language, it already contains some legal meaning which people with qualification has been analyzed very precisely. So it can be problematic for the ordinary user to be aware of the regulation existing in copyrights. Even though it was quite good way for limitation of automatic filter. In my opinion, shift from pre-flagging to pre-checking attitude is not consistent with the part of the Article 17 when it states that the application of this article shall not lead to any general monitoring obligation. Among other paragraphs that I just have time to quickly mention is, for example, assuming those regulations as juris cogens, so they cannot be accepted by the contract. And there is also a creation of the legal presumption that small platforms cannot manage to fulfill the directive. So it was the short description of the German draft. A lot has been told already, and I am very curious what will be in the final shape of the new act. It is not a mystery that Germany, as one of the leading countries, becomes a trendsetter in the legislation. So their solution will be just copied to some other EU members. So then the discussion becomes even more interesting. Thank you.
Oh, thank you, Edita, and for that speech. And now we are moving on to the questions. And frankly, we got quite a lot of them. So the first question is to Julia Reda from Maria Świetlik. Julia, what would you suggest as an alternative to Article 17? Can it be improved, or the completely different solution is needed, or maybe there is nothing to improve in that matter?
Thank you. I think an alternative could be something along the lines of what Edita just said about the German proposal, which is a compensated exception for everyday uses such as memes. But I think it would be very important to more strictly limit such a system to the platforms where there is really a problem with copyright infringement, because I think Article 17 has two major problems. One is the upload filters, but the other one is also that it targets YouTube, Facebook, maybe Instagram, but it actually might end up covering lots and lots of other platforms where there is no big problem of copyright infringement. So I think an alternative could be to say, okay, we introduce a new user-generated content exception that covers things like very short parts of video, and platforms have to pay a compensation for it, but it would have to be much more strictly defined which platforms we are talking about. But I think this could, on the one hand, solve the issue that some of the revenue from the really big platforms that do have quite a lot of copyright infringement goes to the collecting societies. But at the same time, it would avoid the introduction of upload filters and would actually legalize the everyday cultural expression. So there could be an alternative solution if the European Court of Justice decides Article 17 should not apply.
Thank you. Also, Jacek Wojtaś is asking Julia, what about works which commercial value lasts very short, like press articles, music clips? Shouldn't they be blocked from the beginning? And after several hours being available, they lose their commercial value after being uploaded, the right holder cannot longer use them commercially.
Well, I don't think there should be any blocking of content that happens automatically, because any system like that, I think, would constitute a general monitoring obligation and would violate fundamental rights. And I think there are no other examples of laws that are enforced automatically by private companies through the use of technological tools. But of course, in the past, the European Court of Justice has suggested some possibilities for injunctions that courts could issue. Like, for example, they could require platforms to block the user accounts of people who share something like a live stream or something like that. But I do think it would be disproportionate in any case to require the use of upload filters.
Thank you. I was quite expecting something like that from you. And now I have the question to Julia and Justin's, or the comment maybe. The Irish exception, section 57, is not limited to Irish published works. Also, there is a license override in place. Would you comment on that?
Yeah, I think Julia has a relatively good idea about the Irish exception. Irish works are the scope of the exception. The second part of the question I didn't understand, but obviously that was a compromise before we had Article 5, so it really had to stick to the territorial limitation. So there is a limitation to certain types of works, absolutely. At least that's the way I and my Irish colleagues read it. and we had a number of discussions with the library that this is probably the appropriate interpretation.
Thank you. Also, Martin Olender is asking you, why would the rights holders not make available such licenses, thus making Article 5 useless? How is the suitable license standard interpreted?
I can take this one. Yeah, sure. I think that's a crucial point. That's exactly why we are emphasizing so much in, do we want an exception in terms of a free zone for for free uses, or rather do we want a balanced licensing scheme? And I think that's something that, it's not that I don't want to share my personal opinion, but that's something that we should look first at how national legislator will actually act. And either it will be on putting emphasis on the role of the teaching exception because we need it and we want the emphasis to be on the education, or rather whether some or all national legislator will look rather at this exception as a potential damage to the right holders. So this will be the interesting, at least for the purpose of our research, this will be the interesting dilemma to solve before we jump into drafting balanced licenses. So probably it's premature to say how a license would look like. We should first expect some good steps ahead from our national parliaments in the EU.
Thank you. Andrei Vekukal comments that our legislator just proposed to implement the exception from exception and to exclude teaching materials and sheet music. So I wonder if there will be any benefit from this exception if it doesn't cover teaching materials. I guess not. That also leads me to my own contemplation that should we make exceptions obligatory, and should we try to standardize the exceptions and treat them as user rights in this light? What's your opinion on that? And probably this question for all of our speakers.
I think there is a certain benefit for even although I say that with a reservation because I'm not convinced by that. There is one advantage of an exception that puts the use of education material and sheet music as suggested as examples, by the way, under Article 5, under the condition of prior licensing, which means that if this content is licensed, it costs money, but teachers have certainty that they are allowed to use these contents. Now, one of the restrictions that we experienced during the last couple of months is that teachers were uncertain what and how much they were allowed to use and to make available to their students online. And with such an exception that is then under the condition of a prior license agreement, teachers would hopefully get certain instructions. The problem is, of course, it will be expensive, and if you can't afford such a license, you will not be able to use the material, at least lawfully, in your teaching environment. So in principle, there is an advantage under the caveat that you are able to pay.
Thank you.
I could also add something on that, perhaps to give a perspective from the legislative process, because I was very concerned about this language in the recitals about sheet music and teaching materials, because I feared that other member states might take this as an invitation to put things under the license override that were actually covered by the exception before. The reason why this wording is there in the directive is because of Germany. Germany's educational exception up until now did not cover textbooks and sheet music. And the German publishers, of course, have a very strong lobby. So in the end, the best we could achieve in the negotiations at European level was to at least include those materials in the scope of the mandatory exceptions, but with the possibility of license override. So in Germany, actually, the situation will improve a little bit, because up until now, sheet music and teaching materials were not covered by the exception at all. in the future they will be covered, but only if there is no suitable license on the market. But I have warned the entire time that if we accommodate Germany in this way, that they can keep this very limited system, that other member states might now use it as an invitation to restrict theirs. And this was definitely not the legislator's intention. It was more making a concession to Germany so they can stick as closely as possible to the system that they already have.
Oh, thank you for this insight. Martin Olender is asking, why would you say that European Union legislators do not seem to adopt this user perspective when designing copyright law? Next chance for a new teaching exception will be in 20 years. That was, I believe, to Justin or to Julia. I'm not sure now.
I think Julia can answer that.
Sure. I'm always the optimist of the show, so I'm happy to take up and just shine some light on what I hope it will be the case. It's a complicated perspective to take. It was mentioned before, I don't remember if it was Edita or Julia, just stressing the point that there is a tradition on embracing the right order perspective, because that's one of the strong tradition we have in the continental view of copyright, but that doesn't absolutely prevent us from modernizing, because that's also the word that the EU legislator uses very often, modernizing this view and technically looking at what's going on in a real life scenario. And I think here I just take the occasion also to link probably all our presentation, in the sense that if actually the new teaching exception in digital environments will actually fail in the implementation system to accommodate the needs of teachers and users, we will have a problem, as we experienced during the emergency with the COVID and the online teaching. We will have a problem of content being removed during the classes, after the classes, in preparation of examination. Filters will signal problems of copyright infringement, and it will be harder and harder for teacher and student to cope up with these new technical hassles and obstacles. So definitely I see all the presentation looking at a very similar direction and joining efforts for embracing a sound user and balanced user perspective.
Thank you. Thank you. Teresa Nobre is asking, do you share the concerns that member states that have good exceptions for digital education under InfoSoc directive will end up in a worse place if they create a new exception based on digital single market on top of those? Article 25 of digital single market states that member states might adopt and keep in place broader education exceptions for those member states that the only element that is essential to introduce is the cross-border aka legal fiction provision. What do you think on that?
Let's hope not. I think it's a very good and valid question that member states might be overly eager to fully take advantage of the opportunities offered under Article 5. But this is, of course, a political decision that will at national level largely depend on the lobbying efforts of the relevant publishers. And these will be textbook publishers. No? So we don't have to bother about the UK anymore, so Oxford and Cambridge are out of the picture. But of course, in countries where these repertoires are relevant, this will become a concern on how far lobbying will succeed in convincing legislators to narrow down existing teaching exceptions. Yeah, but because we don't have many suggestions so far, we simply don't know. I hope this is not going to be the case.
Thank you. We got a question from Maria Świetlik to Edita and Julia. Flagging sounds interesting, but still, I guess it will be verified after uploading by algorithms based on notice. So I'm worrying that it will be impossible to ensure that exceptions based on context will be respected in any way. Edita, what you think on that?
Yeah, but I think that the point of pre-flagging was to omit the upload filter. So this problem is solved, kind of, if then there can be a complaint of somebody, because then there is a plan. It would be a plan to, if the user constantly flag the content incorrectly, then it can be blocked from uploading anything. Just like I said, the problem is with that paragraph 12, when it states that something can be obviously incorrectly flagged, and there is a limitation for those 90% of content is the same like the repertoire provided by the right holder. So here is the problem, that actually the upload filter will be enforced, but there is no problem with the flagging and then complaining afterwards with the uploading filter anymore.
Yes, I agree with that. I think the problem is that this 90% rule. So in the German proposal, it says something is obviously incorrectly flagged if it matches with the right holder information by 90% or more. There are some exceptions that allow the use of 100% of a work. So for example, a quotation can quote a whole work if it criticizes the whole work, for example. Also in Germany, we have an exception for communication to the public of religious services. This wasn't a big deal so far, but now during COVID, suddenly actually live streaming of religious services on YouTube is a thing. And this exception also applies to whole works, so they can sing an entire song or something like this. The bigger problem is maybe even with Creative Commons and public domain content, because there it's quite often 100% of a work that is used completely legally. And the German proposal does not include sufficient safeguards to ensure that Creative Commons users do not get accidentally blocked as well, because sometimes the alleged rights holders make a claim for blocking something on which they actually don't have exclusive rights. They only have non-exclusive usage license. And in this case, I think the flagging system will not be sufficient to ensure that Creative Commons or public domain material does not get blocked.
Justin, you would like to comment on that, please?
Yeah, very, very briefly. I mean, obviously, we're dealing with a very fundamental question here, and that is a normal decision that we have to make. I mean, I'm fully in favor what Julia has suggested, that we should have a user-generated content exception. But the problem will arise at any point in time that we have to see how much do we permit in terms of quantity, because this is what algorithms can eventually detect. And from what I'm informed of is algorithms aren't context sensitive. So this clearly isn't an option currently. And the normative decision must clearly be, and Julia has done that very nicely in her thesis, to decide, do we put fundamental rights? We put it up and then we see further first, or freedom of expression first, or do we take the right to property, which is always omitted in the discussion, but which is still there. Now, we shouldn't forget it, but the question is, what do we weigh higher? And if you look into the case law of the Court of Justice, and I can really only recommend the study, it clearly states disabling content ab initio is not permitted under Article 10 of the ECHR or Article 11 of the Charter of Fundamental Rights of the European Union. And this is the normative decision we have made in our fundamental rights instruments. So this shouldn't be an option whatsoever from the very beginning, but we then, of course, have to find a way that we get a proportion of potentially infringing content out. And there we have to find an agreeable way. It will be a limitation of freedom of expression, but it must be proportionate, and it must stay, or it must be in a relatively well-balanced relation to the other fundamental rights involved. Conduct the business, access to information, and so on and so forth. And that's the discussion I think we must be having, and not whether it's 30%, 40%, or 50%.
Yes, and Julia.
Well, I think I just wanted to say something similar, but I take the opportunity of build of that. I think I would frame it as more of a question to Julia in this case, because during your presentation I was thinking in these terms, thinking about the clashes being between right holders or users, but also, and here is my addition, the new clash being also between the human and the machine. So without pushing the boundaries too far and looking at AI and copyright, but my question for you in terms of suggesting probably a better way to deal instead of with Apollo filter, but a better way to deal with platforms and copyright. Do you see a changing role of copyright, like a changing function of copyright in the future? Also, I mean, from your insight from the legislative discussions.
I think it's possible that technology changes the law or changes what we consider should be the law. At the moment, there is a complete mismatch between what copyright law says and what upload filters do. Upload filters, like it was already said, cannot see context. They also don't know whether something fulfills the criteria for copyright protection, whether it has originality. They also don't know who the right holder is. And the Berne Convention says there cannot be formalities, so we don't have a public database of works and right holder information. So it could be that an increased reliance on upload filters would end up changing the copyright law. It would create pressure instead of having context-sensitive exceptions like parody, where it's about whether something is humorous, or quotation, where it's about whether you are discussing something. Could be in the end that 20 seconds are allowed and 30 seconds are not allowed. I think that overall, this would probably be a very dangerous development, because the exceptions that we have are there for a reason. Exceptions like quotation or parody or pastiche are there in order to protect freedom of expression, but also freedom of the arts, freedom of the sciences. And these quantitative exceptions would not be able to do that. Nevertheless, I think having a sort of de minimis exception would be a good idea. So I'm glad that Germany has introduced this option into the discussion, simply because copyright law is too complicated for average users to understand. And a simple rule like saying you are allowed to use content up to a certain threshold is something that everybody can understand. So I think we're going to face, whether we use technology or not, we're going to face a situation where we have to drastically simplify copyright law, because if we want average people to follow the law, they have to be able to understand it. And at the moment, this is absolutely not the case.
Thank you, Julia. We are slowly running out of time, so this will be the last question. It's from Szymon Andrzejewski. I heard that Latvia during pandemic times has created special license approved by a parliament that let all national heritage digital materials to be liberated from copyright. Is it possible to do it with all copyrighted educational materials to help creating educational materials and using educational materials by teacher in a country like Poland? I would add from myself that obligatory license is a solution for the problem which has been proposed for many years, but it never got like enough foothold. It was so what's your opinion on that? Is this the way of the future, the obligatory licenses, or how in any other way we can guarantee the basic freedoms and including freedom of speech or freedom to teach? And I think like everyone, if every one of you could voice your opinion on that very shortly, that will be like a nice finish for this session. Julia, maybe we'll begin with you.
Well, I mean, from a German perspective, this would be kind of an attractive solution because our education exception is already subject to compensation. So in this case, actually an obligatory license that would cover all uses for educational purposes, as long as the license conditions are also dictated by law. And so the amount of compensation wouldn't change, would be quite simple and would make lives of students and teachers a lot easier. But I think these obligatory licenses would always be subject to a license fee. So in countries that don't have compensation for the education exception, it would be a real step back.
Thank you. And I was thinking not only on the educational exceptions, but in general on reuses of other works. Justin, maybe you would like to be next.
I think this discussion would then essentially morph into one of an almost culture of flat rate, which I think is still dangerous and politically relatively unfeasible. But let's stay for a moment with education. I think it's a really good idea as long as this wouldn't de facto place the applicability of other exceptions, because even in teaching, there are obviously exceptions that have an overlap. And if we then have a paid for teaching exceptions, schools and universities might in the end be required to pay more than they normally should be required to pay. If we have a very, very simple exception that only covers those users that aren't covered by another exception, basic quotation for exception. So I'd be very, very careful there. But in principle, it would probably be an easy idea to provide teachers with the certainty they need to do their job and to exercise their right to academic freedom, which includes the right to teach.
Thank you. And Julia?
Fully agree with both the comments before. I don't think I have anything to add on the merits. I see the point also of COVID shaking a little bit the situation. So it's not by chance that the only implementation of Article 5 we have is Hungary during COVID in order to facilitate the use of teaching material in the digital environment. So that was one of the examples I also hinted at, but on a pragmatic level, I fully agree with what was already said.
Thank you. Edyta?
Well, I think that it has been said by the Professor Lessig that people who are at the beginning of the legal way are more tend to limit everything and regulate very strictly. And keeping that in mind, I'm trying to see more the purpose of the copyright, even if there are some voices that the copyright that we have doesn't stick anymore to the reality and the technology that we have. But I would keep in mind the proportion and what is really important and what we really want to protect by copyrights.
Thank you. So I think this is the end of today's session, and thank you all for participating. Thank you for all the questions, and thank you to our speakers, Julia Reda, Justin Jute, and Julia Piora, and Edyta Bednarczyk. I hope you enjoyed today's session. If there is anything we should improve, please let us know in the comments. This is the first time we are doing this conference in such a format, so we are really eager to learn from our mistakes. And yes, I invite you for tomorrow. Tomorrow we start at 5 p.m. Central European Time. Please check the program at copycamp.pl. And tomorrow's session will be Directive 2019-790 implementation and interpretation. So we will continue the topic of implementation of the Digital Single Market Directive. And we invite you also on Friday for the session on games, favorite topic for many of CopyCamp audience. And that's all for today. Thank you very much, and see you tomorrow.